BIA's decision and remand for the BIA to conduct a proper reasonableness analysis that accounts for the many relevant factors that rendered the amount of time here unreasonable. I welcome the court's questions.
Counsel, is the standard under the statute the same as the standard under the Due Process Clause?
We believe, we don't take a position on whether the standard in all cases would be the same. We do, and we don't think the court needs to decide that in this case. We do think that, at least for purposes of this case, both the statutory and the constitutional right were violated. But we don't take a position on whether there might be certain cases where the standards might diverge for one reason or another.
Wait, so I read your brief as pretty clearly taking a position that they're exactly the same and not providing any support whatsoever for that assertion. So are you walking back the assertion in your brief, or are you making a different assertion today?
So if I understood the question correctly, and perhaps I didn't, I apologize. I understood it to be whether the two rights are sort of coterminous or the same. And as for what the applicable standard is,
right? But on your brief, you said they were equivalent, which is another way of saying they're the same. So are you not? Are you still saying that, or are you not still saying that?
As far as I'm aware, the standards are the same, and we think as applied here, they are the same. But we don't think the court needs to take a position in this case on whether they're exactly the same, on whether there are cases on the margins where the standards would apply differently. But for purposes of this case, they're definitely the same, and we think the inquiry proceeds in the same way.
And so then, pursuant to the doctrine of constitutional avoidance, I guess we would not need to reach the due process issue, if I'm understanding you correctly.
That's exactly right, Your Honor. We think that the narrowest way to decide this case is the statutory route for a number of reasons. For one, under the doctrine of constitutional avoidance, but also because, as I understand the government is not disputing that there's no prejudice requirement under the statutory standard.
Well, see, now I have the problem with that is that I don't understand how that makes a lick of sense, because there is a prejudice requirement under the Due Process Clause, and so I don't understand how a statutory right that implicates an underlying constitutional provision could be more favorable to the non-citizen in this context than the Constitution is.
Your Honor, our position is that there is no prejudice requirement under either standard. So I agree with you that it would be inconsistent to have a prejudice requirement under the constitutional standard and not under the statutory standard. If I had to guess, the reason that the courts that have found a prejudice requirement under the constitutional standard have done so is because they've been applying, without reasoning, the general procedural due process requirement in this context.
And by courts, you mean including this one, which has said that?
I don't read this court's precedents to squarely decide that issue. And I can go through the cases that the government cites in support of that proposition. I read the case as most heavily relying on Jean v. Gonzalez. But in that case, the court...
Wait. What about Rusu?
Rusu was not a right to counsel case, Your Honor.
But it is a due process case, and we said the Due Process Clause requires prejudice.
Yes, it is a due process case, but it is not a right to counsel case. And I take the Supreme Court's precedent to clearly state that the deprivation of a right to counsel is an error that's different, categorically different from any other sort of...
Well, hold on. The Supreme Court has said the deprivation of the Sixth Amendment right to counsel, but we're pretty far afield from the Sixth Amendment because we're in a removal proceeding where the Sixth Amendment doesn't even apply.
I agree that the Supreme Court has said that in the context of the Sixth Amendment. That said, the reasoning the Supreme Court has used to find that there is no prejudice requirement is not dependent on the fact that the right comes from the Sixth Amendment. Gonzalez-Lopez, I think, is the best case on this. In Gonzalez-Lopez, the court was considering whether the deprivation of the right to proceed by counsel of one's choosing entails a harmless error analysis. And Justice Scalia, in that case, when he was evaluating the harmless error question, his reasoning turned entirely on the nature of the error and specifically on the impossibility and impracticality of conducting a prejudice or harmless error analysis when the deprivation is of this sort. And the reason, he said, is because when you're dealing with the right to counsel, doing a harmless error analysis requires speculating about an infinite number of questions and different decisions that a counsel might have made differently. Not just that, You might have to evaluate the counsel's demeanor in the courtroom, the counsel's relationship with the prosecutor, and so on and so forth. There are too many uncertainties, and the end result is that the harmless error analysis becomes completely speculative. And
so is it not that prejudice is required, but that prejudice is presumed in these circumstances, rather than what you're suggesting, the prejudice is not a requirement? Is it fair to say that prejudice is a requirement, but it's presumed under the circumstances of deprivation of right to counsel?
yes, Your Honor. I think courts have also put it that way, and either way, the end result is the same as we see it. In both situations, the burden is not on the non-citizen to prove that there was prejudice in any given situation. And you
Counsel,
yes.
Counsel, can I maybe go back to whether there's the question of whether there's a violation before we get to prejudice?
Of course.
If we're talking about the statutory right, I understand your position to be, I guess it says privilege, not right, but put that aside. But whatever it provides, you contend that it means a reasonable amount of time to obtain counsel, as I understand it. And I understand your position to be that interpretation of the statute is a question of law, whether it means a reasonable amount of time or not. You know, assume I'm with you so far there. Isn't then the agency's application of that standard, whether there's a reasonable amount of time, a question of fact?
No, Your Honor. I understand that it certainly involves certain factual application of certain standards to the facts, but this is, I think, a classic sort of reasonableness, totality of the circumstances inquiry, which this court said in Williams. This court historically and has long consistently reviewed de novo.
So you would say an immigration judge lists a bunch of reasons why continuance is not granted. You would say even if we grant grant that the standard is a reasonable amount of time, that we would de novo review the immigration judge's application of all those factual factors?
That's correct, Your Honor, and I do think that's consistent with this court's decision in Williams. So in Williams, for example, the court was reviewing an equitable tolling issue, and of course those inquiries are different. That inquiry is different from the one at issue here, but it's similar in the sense that it involves a consideration of factual circumstances and the totality of the circumstances. And this court specifically considered whether or not that was a question that veered more in the factual direction and therefore wasn't subject to de novo review, and it squarely held that it was subject to de novo review on the grounds that these totality of the circumstances inquiries often involve determining auxiliary legal principles, what factors are relevant, what factors are not, which factors should be weighed more heavily, which factors less heavily.
Can I just ask you, this has just been bothering me about this case, like this whole framework, this picking up Judge Quattlebaum's question. I want you to imagine this was a criminal case. It's not like we don't see these criminal cases, right? The defendant's lawyer withdraws, and he says, I need 6 months to find a new lawyer, right? I need a 6-month continuance to find a new lawyer. And the trial judge says, like, that's ridiculous. It doesn't take you 6 months to find a new lawyer. 6-month continuance denied. We are going to trial as scheduled 2 months from now. I just don't think there's any way we would ever review that decision de novo as an appellate court. It seems inconceivable to me that we wouldn't review that seemingly to me extremely analogous situation. Because technically speaking, right, it's not like, when I think of denial of the right to counsel of choice, these are cases, to me, the classic example of the case there is where the trial judge wrongfully concludes the lawyer has an unwaivable conflict of interest and thus forbids that person from being your lawyer, or refuses to let you represent yourself and thus denies the right to self-representation. This is at best an indirect denial of the right to counsel of choice. It's the indirect denial by refusing to give more time to find another lawyer. And it seems to me that if this was in the criminal context, we would defer quite heavily to the trial court's assessment about whether you had enough time to find another lawyer. So it just seems weird to me that in this context it would be less deferential. Could you tell me what's wrong about that?
Your Honor, I'm not super familiar with the standard of review this court would necessarily use in the criminal context. That said, taking the premise of your question that this court would review that deferentially, I do think that under this court's precedent in the context of removal proceedings as well, what matters is the discrete question that's underlying the decision that the IJ or the BIA made. So it's true that here the decision made was to deny a continuance, to give to refuse to give more time. But the question that's being raised on appeal here is whether that decision violated my client's statutory and constitutional right to counsel.
But it violated it if and only if the IJ, like, so I guess we all agree that if someone walked into a hearing and said, well, I can't proceed today, I don't have my lawyer with me, and then the IJ says, well, where's your lawyer? And it's like, I just forgot to tell her. The IJ could say, forget it, we're going to the hearing today, and we would never consider that a denial of the right of counsel of choice. That's the failure to show up with your lawyer. So I know you want to turn it into the denial question, but like it feels to me like lots of enterprising litigants could try to turn something into the denial of the right to counsel of choice. You forced me to go to trial on the day that my lawyer was really busy. And normally we would not say that's the denial of right to counsel of choice. Why?
I do think that the Supreme Court, for example, has treated situations like that as the denial of the right to counsel. So, for example, in Chandler, I believe, in Reynolds, the defendant there had an attorney, but the attorney couldn't make it to that, wasn't there yet. And the Supreme Court said, all right, the denial of a continuance in that case was the denial of the right to counsel. So I do think that even though I understand Your Honor's question that it's a step removed from precluding the attorney from entering the courtroom, it can't be that that's the line drawn by the right, because otherwise the right would be effectively meaningless. So it has to be that the right includes something more than just you get to walk through the doors with your counsel.
So counsel, just kind of going past that issue of how we review it, is there a decision in the immigration context where any court has held that 6 weeks is not enough time to get counsel? I mean, I know you want to probably challenge the 6 weeks premise for some things, but just humor me and say I think it's 6 weeks. Is there any decision that finds that to be insufficient time?
Yes, there are multiple decisions, Your Honor. So I would point you first to Usubakunov. That's a decision from the Ninth Circuit. The court there found that the non-citizen had 201 days, so roughly 6 months to find counsel, and his inability to do so in that time did not mean that he wasn't entitled to a continuance. And the court there looked at the totality of the circumstances and determined that given his circumstances and the obstacles he was facing, 6 weeks was not a reasonable opportunity. I would also point this court to Freza. That's a Third Circuit decision that we cite. In that case, the non-citizen effectively had 1 year to find counsel, and the court still found he was entitled to more time to find counsel. I just want to caveat that Freza was slightly different in that the non-citizen there showed up to his hearing with a lawyer he had found 24 hours before the hearing, and his lawyer then withdrew after not being given more time. But analytically, I don't see
What's your position of how much time your client was entitled to as a matter of the statute?
I don't know exactly how much time, Your Honor. That said, the record suggests that had she been given even a little bit more time, say a few weeks, a couple weeks, she may well have succeeded in finding an attorney. She told the IJ.
So how do we know? I mean, you're entitled to come here and say what's wrong, but it's a little bit hard to say what's wrong when you won't say what's right. So if you could, and I know you think it's case specific, so I'll limit it to this case. What would be the amount of time that under the statute you say your client was entitled to?
In this case, I think a reasonable continuance might have been another 30 days, for example. It would depend on a number of factors, including, for example, whether it would depend on a number of factors, and I'm sorry, I'm parroting that to Your Honor, but I think in this case, given that my client managed to contact Attorney Lopez, who ended up representing her on appeal before the BIA, right before the hearing, right before her pre-hearing submission deadline, it seems very likely that given a month or maybe even less time, she may have been able to secure her
But it sounds like the answer to your question kind of means, well, we just got to see whether it works out that the lawyer's there and ready. So it sounds like a kind of squishy way of looking at this, that, we got to see, because maybe Mr. Lopez would have, had another case and it would have taken 5 weeks rather than 6 weeks. I mean, I don't see a lot of, ability to ever know under the way you're looking at it. And I know you're over time. If you could answer, you certainly have permission to answer that.
Thank you so much. I sympathize with the sort of squishiness of the inquiry. Starting there, though, I will say courts routinely do apply this kind of squishy inquiry and then leave the ultimate decision of how much more time to the IJ or to the BIA. The second point that I'll make on this, Your Honor, is that the BIA didn't engage in any of this sort of analysis and jumped straight to the fact that because my client had approximately 1 month, she had a sufficient amount of time. And so even if this court disagrees with everything I'm saying, at a minimum, the BIA itself should have tried to engage more in this multi-factor inquiry. And then the last point I'll note is that while it's true that it's hard to pinpoint an exact number of days, I think that's just true in any reasonableness inquiry. Reasonableness is by nature a squishy factor, but it's one that this court applies regularly in other contexts, and this is just yet another context where I think the law requires it to be applied.
Thank you, counsel.
Thank you.
Mr. Couch?
Good morning. May I please?
Hold on a second. I'm sorry. I think I want to make sure the clock gets set before you begin.
I believe I reserved.
I'm
20
sorry to
minutes.
interrupt.
Whoa, excuse me again. I think that's the wrong amount of time.
The time should be 20 minutes.
Yeah. All right, there you go.
Good morning, and thank you so much for that. This is Greg Helch representing the U.S. Attorney General. I'd like to begin by pointing out we think that this is a very narrow issue that's being presented to you here. In a lot of right to counsel cases, they often arise with petitioners, usually detained, usually indigent, who end up going through the process and they never have a lawyer to help them. And we later find that the immigration judge should have granted more time under the circumstances and didn't. And courts struggle with the prejudice inquiry there because you just don't know really what would have happened if the person had had a lawyer to go over their rights with them and to potentially help them prepare their case. This is entirely different. Ms. Rodriguez had counsel who diligent counsel, it appears, helped her prepare an asylum application and a written statement and was able to get witnesses and an interpreter for a witness and also documentary evidence from Honduras. So she had a lot of help in presenting the foundation of her claim. And so what happened here is when she showed up at the merits hearing, the previously scheduled merits hearing, well, Ms. Aziz had withdrawn from the case. All we know about that is that she says that her client failed to cooperate with counsel. That's all we know. And the immigration judge made a decision we would go forward, and the immigration judge would take the testimony. And I would refer the court to the transcript, but what she said was she wanted an attorney to help her present her case, not to look at new claims, not to further investigate it, just to present her testimony. So from a Fifth Amendment perspective, does it make the hearing fundamentally unfair for someone to testify without a lawyer? Well, certainly not. That happens every day. That happens every day in immigration courts. So it's not a due process violation. Is it a statutory violation? Was she denied the right to have an attorney? Well, absolutely not. Nobody told her that she couldn't have an attorney. That's not the issue here. The problem is that she wanted more time to find an attorney. And so Now we get to the question of matter of CV. The BIA looks at, did you have a reasonable period of time under the circumstances?
So do you disagree with the reply brief's assertion that Ms. Lopez was never told that she'd be required to represent herself if she didn't have a lawyer?
Mm,
The reply brief at page 12 asserts that she was never told that by the IJ.
Your Honor, I don't recall reading in the record that. I think because at the prior hearing,
So what I'm asking you is, are you prepared to I presume you read the reply brief. Are you prepared
Yes,
to say that a statement of fact that is made in the reply brief is wrong?
I am not prepared to say that at this time. If I find otherwise, I can let the court know. But there may have been something at an early master calendar hearing, but because she was always represented by counsel, then probably just hadn't come up in any of the earlier hearings. So, but still, the immigration judge took the testimony from her and asked her about the claim. And
But we would never, hold on, we would never say that a criminal defendant who's sitting at trial, whose lawyer gets COVID or something, and the judge says, we're going to trial today, but no big deal. All we were going to do today was take your testimony, and we can do that without your lawyer here. No one would ever say that that's not the deprivation of the right to counsel.
Oh, well, I appreciate you raising the question. I think that brings us to the question of Romero v. Bondi, the decision that this court entered after briefing. Romero v. Bondi specifically said the Sixth Amendment only applies in criminal cases. It doesn't port in all of the Sixth Amendment.
No, I'm not trying to import in all of the law of the Sixth Amendment. I'm just saying, in response to the argument that Ms. Lopez didn't have counsel of her choice at the hearing, you're like, it's no big deal because all we're doing is taking her testimony. And I'm just analogizing to a criminal case that we would never say we wouldn't say that in a civil case. We wouldn't say that if, like, all we're doing today is taking the defendant's testimony, it's no big deal if the defendant's lawyer couldn't be there and the judge refused to grant a continuance.
Well, in Russo v. INS, this court held that the government does have a special interest in enforcing immigration laws, and we have a tremendous backlog of cases. This case had been pending for many years, some of it with administrative closure, which the government agreed to and she agreed to. There were other extensions for her pregnancy. Yes, there's one for COVID. Yes, we had all the witnesses assembled. We also had a Honduran Sign Language interpreter, which are hard to find. And yes, we do assert that it is reasonable under those circumstances for the immigration judge to say, well, we're going to take the testimony. I'm going to lead you through this.
Well, hold on. You just mentioned several things that this got delayed. So in terms of other things that are represented on the other side's brief, they also represent these hearings were postponed several times sua sponte by the IJ. Is that also correct?
Sua sponte, one was for the pregnancy. She requested a continuance. For the COVID continuance, I can't really characterize like whose continuance was that. She was exposed to COVID and didn't have a negative test, so it just couldn't go forward. So
I think Judge Heitens is talking about the several administrative notices of postponing the hearing that both parties seem to say there's real no explanation for, and I take the implication of it to be is that really to be held against her if the IJ administratively does that for whatever reason?
Well, Your Honor, it is part. I mean, it is part of the backlog of the case. I'm sorry to say that, but the immigration courts are very busy, and sometimes cases are in fact rescheduled.
But that's a different point. I mean, you may have a point that the case is old and needs to be processed, and the government has an interest in that. I think that's a point. But to the extent you're talking about multiple continuances, if she didn't request them, I wouldn't think you would be able to say those are somehow, negatively or attributable to her conduct.
Well, then perhaps I should bring the court back to what is our primary point in our briefs, which is that from her own testimony, what she said in immigration court was that she had started looking for an attorney after what she says the Pereira motion was denied. And so that had happened at the August 9th hearing, and that takes you to October 18th. So by our calculation, that's about 2 months for her to be looking for an attorney.
So counsel, I'm sorry to cut you off before you finish that point, but this relates. I had asked your colleague, the way we should look at the agency's decision about, saying basically about continuing the case, which seems to get at whether or not the petitioners had enough time to find new counsel. In your brief, you say a due process violation we review de novo, but I didn't see anywhere where you state how we should review the IJ's decision under the statute to determine whether or not the petitioner should have more time to get counsel. Is it? We're not necessarily bound by the parties' positions on standard of review, but do you view this as a question of law, or do you say that we should look at the IJ or the agency's decision with some deference?
Well, so first of all, just let me say with regard to the statute, because I made the point before, and I do want to emphasize it again. Nobody denied her the ability to bring an attorney to court. I think if you ever have a case where the immigration judge says, no, you're not allowed to have attorneys, I do all of the testimony myself, that would be.
Thank counsel. I'm not trying to keep you from making that, and I understand that argument. I think you've said that, and my question's not to indicate I agree or disagree with that. I'm trying to focus, though, on what happened at the hearing when she requested a continuance. And let's assume, just for the sake of discussion, we're just talking about that and the question about whether she should have had more time to get a new counsel. That immigration judge went through a bunch of reasons that she decided not to permit more time, and the BIA affirmed that decision. Is our review of that a question of law or a question of fact?
Well, the way that we looked at it was that they could have crafted their claim in one of two ways. One is you could say that this is a constitutional Fifth Amendment violation of due process. And for there you have de novo review, which is a very generous standard of review for this court, but it's a very high standard of error. They would have to show that it's fundamentally unfair. They could also craft their claim as an abuse of discretion. So there it would be sort of a lower standard of error, which is just simply should the judge have given her more time. But then there would be a much more deferential review. Would be
but what's your basis?
Review.
What's your basis of saying that if we're not in the due process world, we're in the statutory world, that it is it's a question of fact that would be for abuse of discretion, as opposed to a question of law that we would review de novo?
Well, I think like in the statutory world, we seem to be focusing in on the question of whether she should have been given whether she needed more time in order to get counsel. And that we are drifting into the reasonableness inquiry and the factual abuse of discretion inquiry that we would say, yeah, what is reasonable? There should be some deference to the agency.
Do you have authority that would support that?
Not at the moment, but I believe that that's just generally a principle that when we're looking at something like reasonableness, that is generally reviewed for abuse of discretion.
Okay, thank you.
Well, I think that your friend on the other side is saying that this is a mixed question, and the question is whether the test that is the totality of circumstances test has been properly applied. So the legal question would be, did the BIA apply the test? And then what are the factors considered? And so I guess the question is, if it is a mixed question, do we review de novo?
Well, I think that any time that you come to the facts, I mean, there has to be some deference to the agency because they decide the facts. You take the facts and apply them to a legal standard. And I guess we just keep coming back to the question of what is she entitled to under the standard, under the statute. She's entitled to bring an attorney with her. The statute doesn't specifically say you must get this time or that amount of time to find an attorney. The only thing we could find was you have to get at least 10 days at the start of the removal proceedings, which doesn't really apply here. It all seems to be turning on the BIA's application of matter of CB. And again, we think that matter of CB is applied correctly here. It's 8 weeks. According to her statements, other courts have found that period of time to be reasonable to find an attorney. And again, this is just a different sort of
Well,
case.
if we're taking the facts as the BIA found them, the BIA finds that the respondent had approximately 1 month before her scheduled hearing to obtain counsel, and then seems to me that the BIA simply finds as a matter of law that 1 month is sufficient time to retain counsel before the final hearing, that there wasn't any analysis of the specific facts and whether and why that would be a reasonable and realistic period of time to speak with, and retain counsel.
Well, but if it's de novo review, then I think you would be able to look at the issue anew. And as we point out in our briefs, she said that she had been looking for an attorney ever since the Pereira motion was denied. So it would be entirely 8 weeks. But still, even at the 4-week level, again, given the unique facts of this case, that she already had an attorney to prepare her claim for her and to marshal her evidence, and she was just coming in to testify in support of the claim, that seems reasonable. And I think it would have been, no one would have even raised a question about this except for on cross-examination. DHS counsel revealed for the first time that she gave a statement that was very contradictory to the statement in support of her own asylum application. Otherwise, this would have been a run-of-the-mill case. Hindsight's always 20/20. People come to immigration court, their attorneys have withdrawn, the immigration judge takes a testimony, and in many cases the application is granted. I think this.
But do they ask for a continuance? But in those run-of-the-mill cases you're talking about, does the individual ask for a continuance in order to be able to obtain counsel?
I'm just speaking hypothetically, Your Honor, but I can imagine the situation where people do request more time, and and more time is not given to them. I think hindsight is always 20/20 because here we had this big explosion when this statement came out that was contrary to what she had said in her own asylum application. And I think now we're all looking back and saying, well, maybe she needed an attorney to help her prepare, for this cross-examination that was coming. But at the time, I don't know that Ms. Aziz even knew that this was going to be the case.
But if she had an attorney there, the attorney might have known to object that they had never seen this before, ask for time to review and speak with their client. That seems to go to the issue of prejudice.
Your Honor, in immigration cases, the rules of evidence are relaxed. I will say that in my years of doing this, there are many, many, many times that DHS counsel brings out a document from the administrative record that we haven't been seen before. They bring it up on cross-examination. Immigration judges always allow that into the record. I can't imagine any attorney would have found a way to keep the statement that she wrote in Mary's case away from the immigration judge. So I just can't imagine that. So I think at that point, the die was cast. But I don't think it was. But again, we always have to go back and put ourselves in the shoes of the BIA and of the immigration judge. The immigration judge is there in the beginning of the case. She doesn't know that this is all going to blow up on cross-examination. It would be we assert that it's a very reasonable thing for the immigration judge to decide we're going to go forward with this case, and I will take the testimony for you.
So wait, you're suggesting that the privilege to counsel, the statutory privilege to counsel, doesn't extend to the hearing? That there's no statutory violation if the immigration judge goes forward without offering an opportunity for counsel?
And again, Your Honor, I'm sorry if I sound like a broken record. I keep repeating myself, but nobody prevented the statutory right to counsel. Nobody prevented her from bringing an attorney with her. The issue here is that she had difficulty finding an attorney within the time that was available to her.
There's no dispute that can violate the right to counsel. I mean, I tend to think your friend's reliance on Powell versus Alabama is a little bit aggressive in this context, but still, like, in Powell versus Alabama, they had a lawyer there. You just keep saying, like, as long as no one stops you from having a lawyer, there can't be a denial of right to counsel. And that has to be wrong, right? There are times at which saying, the trial starts right now, and you say, well, my lawyer is in traffic, but she'll be here in a half an hour, and the judge says, we're going to trial right now. That's denial of the right to counsel, right?
Under matter of CB, that absolutely
Under
would
normal
be.
human speech, that's a denial of a right to counsel, right?
Uh, Your Honor, I'm not prepared to go that far. I think that we have a statute.
You can say there's no situation in which saying, please, 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 please don't start the hearing. My lawyer was just in a car accident, but the good news is she's rallied and she's 5 minutes away. And the IJ says, nope, we're going forward. You wouldn't even concede that's the denial of a right to counsel.
Well, the car accident hypothetical, that is a very powerful one. I think my concern, why I don't want to concede things to you, Judge Haytens, is that, I don't want us to get into a position where someone comes to court and says, I'm not ready today because I don't have an attorney, and I'm not ready the next hearing. And I think you alluded to that in an earlier question. Even in criminal cases, you can't just keep coming back to court and saying, well, I'm not ready because I don't have my chosen attorney yet. So, to us, what we see in the statute is that you have a right to bring an attorney with you to court. And as far as how much time you need, we think that is all provided for under a matter of CB. I don't think that, and I'm not sure if this court is prepared to issue a decision that says you must be given X amount of time or X amount of time in these circumstances. We can certainly think up all sorts of hypotheticals. But when you have a case where somebody has already had an attorney, has already prepared the case, provided the documents, and has already been given 8 weeks, has been looking for an attorney for about 2 months, we would assert that there is no reason for the court to find error in the agency's decision and remand for further proceedings. And I thank you very much for your attention.
Judge Heitens, you have any other questions? Judge Berner? Thank you, counsel. I think counsel, you have now, let's let the clock get set and then we'll let you go to, there we go.
Thank you.
Sure.
I'd just like to address a few points that were raised in my friend's argument, Your Honor. Starting, I think, with a standard of review. I do really think Williams is on point here. My friend on the other side did not identify any authority suggesting that this sort of reasonableness analysis is not subject to de novo review. And if you look at 59 F 4th at 637 to 38, this is where this court in Williams lists a number of reasonableness tests that it has historically evaluated de novo. And it says this totality of the circumstances test is exactly the sort of situation where courts might be making ancillary factual determinations, but the thrust of the inquiry is legal and therefore reviewed de novo. At most, I think the specific factual premises of a reasonableness analysis might be evaluated for abuse of discretion, but that's exactly why, as Judge Berner pointed out, the BIA's reliance on the single month, approximately 1 month time frame here is a premise that need not be questioned in this case, given that that's a factual premise the agency was relying on.
So counsel, could I stop you there? I mean, you've said several times that the BIA just talked about 1 month, but I'm looking at JA4, the BIA decision, and it's 2 paragraphs of discussion about the continuance question. It lists a lot of things that the immigration judge talked about, lists a bunch of facts, and it certainly said approximately 1 month. I mean, it looks to me like the BIA largely summarizes what the IJ did, and that if we look at the BIA, it's not just the 1 month, and it's the consideration of all those factors in there, including that she had been represented before. So anyway, maybe I just feel like seems to be singling out one part of a 2-paragraph discussion of that, where you also affirmed that immigration judge that listed other factors.
Your Honor, I read JA4 a little differently. I read that first paragraph on JA4 as essentially summarizing the IJ's reasons for denying the continuance which really were just that the case had been pending for 10 years and that the IJ and the government were ready to go. We think that would have been invalid for its own reasons, but the decision on review here is just the BIA, so I'll focus on that. And then the second part of that paragraph just summarizes the argument that my client said she didn't have enough time to find an attorney. But that's oversimplifying the arguments that my client made, notably when she was proceeding on her own. She made a number of other arguments to the IJ. This is on pages 127 to 128 of the JA that the BIA didn't even mention. For example, the fact that the court was facing a difficult time when she was looking for counsel. Of course, it was in the middle of COVID. There was a border surge. She explained that attorneys weren't scheduling things from less than a month out. So again, that's missing from the BIA's analysis. And then I take that second paragraph to be the BIA's conclusion, saying we ignore all of that, or excuse me, we reject all of that, and we hold only that she had approximately 1 month and therefore enough time. So that said, even if this court were to review the IJ's reasoning, I still think the result is the same. The IJ, and this goes to something that my friend was discussing, the IJ relied on the amount of time that this case had been pending, but as Judge Heitens and as Judge Berner noted, much of that time was not attributable to my client's, to anything that my client did. Many of those continuances were sua sponte by the IJ,
But
and
if
many of
the
them.
council, let's just, I grant you, I think that's a fair point, but, I mean, let's cut it in half. I mean, if the case has been pending 5.5 years, you know, I just picked that, maybe you would say 4 years, but, I mean, the case is old, and, you know, trial judges in administrative context and in every other context in the world, you know, have an interest in moving cases along. So maybe 11 is not all attributable to your client, but under any circumstance, the case is old, and that's a factor that would weigh against your client, wouldn't it?
I think it depends on why the case is old, Your Honor. I think if the only reason the case is old, for example, you can imagine a case that was administratively closed for 20 years and was reopened. I don't think it would be fair in that case to hold the length of time the case had been pending against my client. And I think the reasonableness test accounts for this. That's the beauty of the test. It accounts for the length of the proceeding and the reasons for the length of the proceeding. May I finish my answer? I see my time is about to be up.
Sure.
Thank you. This is why I think if you look at other cases that apply the reasonableness test, they focus so heavily on whether the non-citizen was delaying proceedings unnecessarily, whether there's evidence of bad faith or dilatory tactics, because that could militate in favor of denying a continuance, especially given the length of a proceeding. But I think in this case, that factor just can't be held against my client.
Thank you, counsel. Judge Heitens, do you have any other questions? Judge Berner? Thank you both, counsel, for your arguments. We'll take this case under advisement and proceed to the next case. Thank you very much. Okay, it looks like we're all set and the clock is set. Sarah, is there any reason we cannot proceed?
No, Your Honor, and Mr. Aby is in the same office as McClatchy.
That's
Okay.
correct.
All right, thank you very much. We're now at case number 25-2023, and we'll hear from the appellant. Thank you.
May it please the court, my name is Scott McClatchy, and I represent the appellant Afacho Sami, a French citizen who is seeking the return of his minor child, a citizen of France, to France after his wife died from leukemia. This is a case about form, not custody. The Hague Convention requires that custody disputes be resolved in the country of a child's habitual residence. And on the record and under controlling Fourth Circuit and Supreme Court precedent, that country is France. I will explain today how the court committed several errors that affected its analysis of the prima facie case, the well-settled and grave risk defenses, as well as the discretion to order the child's return. Very importantly, at the outset, the court below erred when it found that Mr. Samey had not established a date of wrongful retention. And here, Mr. Samey testified at trial that October 14 and 2023, he demanded the return of his child. When he was rebuffed, he then went to the French Central Authority and filed a Hague application demanding the child's return on October 27, 2023, just 1 week later. And Article 30 of the Hague Convention states that Hague applications shall be admissible in court. And in the alternative, at trial, Mr. Samey also introduced evidence that he sent a text message to the appellees demanding the child's return. And in that text message at trial, the appellees admitted through the aunt that they had received it and that they understood it to mean a demand for return and nevertheless rejected it. And the court erred by failing to recognize either of these two wrongful retention dates. And as for the Hague application date, courts such as Babcock versus Babcock have held that that's an objective, unequivocal withdrawal of consent as a matter of law. And it was error for the court to just disregard those dates. And had the court been uncertain about the dates, we actually requested the opportunity to brief them post-trial, and that request was rejected. Now, once the date is set, we then have to—
Wait, hold on. We didn't set a date. You gave me a series of dates and said the court erred by not crediting one of those dates. But the problem is, to get to one of the defenses, it's not enough to say he did it at some point. I have to know when he did it. And you haven't actually told me. The district court erred by not finding we proved it was on date X.
Your Honor, and what we've done is given two potential dates. We actually introduced several dates at trial. We said it was October 14 and 2023 when we called. Mr. Samey called the appellees. But we also say that at the very latest, it should be October 27, 2023, which is the date the Hague application was filed demanding return of the child. That is an unequivocal withdrawal of consent as a matter of law, according to Babcock v. Babcock. And Article 30 says that date comes in automatically through the treaty in international law.
Well, it maybe comes in, but I don't know how the retention— if I, just in colloquial language, if someone has like dropped off their child to stay with me for some period of time, I don't think that my retention of them becomes wrongful, not just until the parent changes their mind and decides they want the child back, and not even when the parent changes their mind and tells some third party they want the child back. It seems weird for me to say that the retention is wrongful until someone tells me that the parent wants the child back, right? So I don't understand how filing with the French authorities does anything to tell the respondents that their retention of the child is now wrongful.
I would actually take that and say that, Your Honor, that if when you are filing something in court, or in this case with the central authority, saying, I no longer consent to my child being in this other country.
Right, and then someone should tell the people who currently have the child that you no longer consent, right? I mean, because if the French authorities like showed up at their door, putting aside questions of international law, but like they would say, what are you talking about? No one has told me anything about this.
And to that point, Your Honor, we would say that our client did call on 2 days before, the week later he filed that Hague application. And what's important is
this the call in which he says, like, I think it's time to figure out a date for the child to come back?
No, Your Honor, that's actually later. That's in December, and that's part of the text message that we mentioned in there in December 29, 2023, when he's asking for the child to return. And just because he asks, let's figure out a date, doesn't mean that he hasn't already asked and demanded the child's return. And so,
counsel, if I could interrupt you there, I think that's fair that later comment that, in isolation might seem a little loose or unspecific doesn't mean there had not been wrongful retention before then. But it seems to me that what the district court said is that almost at every date that you propose, and as Judge Hyten said, it seems like, a number of dates are kind of proposed in the alternative, which, again, nothing wrong with that, but there's counter evidence to each date, including evidence after, October, when he filed the petition with the French authorities. So, I mean, I understand the arguments, and I think there's some arguments that he can make and some facts that support it. But whether we're talking about October or earlier, is this something that there's not conflicting evidence that the district court's looking at and saying, look, I just see evidence on both sides here, and there's not enough to convince me that it was wrongful retention?
And that's a fair question, Your Honor, and it would just go back to, we contend that there was a certain date, they contend there were other dates. But at the end, the inquiry stops when our client goes and files the request in the Hague application with the French Central Authority saying, I demand my child back. And that, once again, Article 30 of the Hague Convention says that is admissible. It comes in to the court. And that is the day which other
let's I'm sorry to cut you off, but I think let's assume you're right. Just hypothetically, that date he files, I think that's October 29, 23. The petition is filed. Let's assume that's the date. Isn't then the next question whether there was a wrongful retention, or where the child was habitually residing before then?
Yes, Your Honor. So assuming that the wrongful retention date at the latest was October 27, 2023, then the next inquiry is, was the child at home in the United States at the time? And so that's where we get into Manaski versus Taglieri.
And let me just clarify, because I think your brief sort of, candidly, I think both the litigants and the district court may have mucked up the date of the of when the child was settled where. We agree that it's not the date the child went from France to the United States, because there's no allegation that was wrongful, right?
Absolutely, Your Honor.
So the question is where the child's habitual residence was, not when she first went from the United States to France, or from France to the United States. The relevant question is where she was habitually settled as of the date the retention became wrongful, right?
That's right, Your Honor, and that's a great distinction, because in this situation we have a wrongful retention, not a wrongful removal. Most Hague cases from our research are wrongful removal. So they're in the one country where they're supposed to be, one parent says, I'm taking them to the United States, and as soon as they set foot in the United States and cross the border, that's when it's wrongful. It's easy to determine. This kind of a case is a little more tricky, because we have potentially, just like in this situation, well, we say it was this day, it was this day, but the wrongful retention is, as we have, just to close the loop, when he filed the Hague application. And then when we deal with habitual residence under Manaski versus Taglieri, Justice Ginsburg explained that a child's residence in a particular country may be deemed habitual only when her residence there is more than transitory. And very importantly, she also said that the intentions of caregiving parents are relevant considerations. And the district court, in its order, found that pre-Manaski Fourth Circuit decisions were just not useful. But according to this court's decision in Maxwell versus Maxwell, whether the parents share a settled intention to abandon the former country of residence is a very important factor. And there are certain factors, such as whether the parents have sought employment in the new country, shipped possessions, or sought permanent immigration status, are all important and are common sense factors that this court has never abandoned. And
so counsel, didn't the district court you make a factual finding on the intent of the mother, that there was not going to be a return to France. Yeah, again, I know that's contrary to your client's, what he said about intent, but we got, the intent expressed by both parents, they seem to diverge. And so why do we not look at that evidence?
Your Honor, that's a great question. This is an unusual case. We have two different parents, and one is now no longer with us, unfortunately. But I think to turn your question just slightly on its head, the important inquiry or fact that the trial court glossed over here is that both parents and appellees expressly agreed and intended that the child would go to South Carolina temporarily while she was seeking leukemia treatment in Paris. And there is no evidence that mother wanted the child's habitual residence to be the United States.
Why do you say that? I mean, it may have been. I thought one of the relatives testified that the mother said, either she's going to come to the United States when her treatment, if it was successful, ended, or they're going to go back to Africa. They weren't going to go back to France. And I mean, again, that's contrary to what your client may have thought, but I thought there was evidence that was admitted and that the district court found credible.
Can I, just to follow on Judge Quattlebaum's question while you're answering, can you also address the question of whether, even if the evidence is credible, whether it's relevant, the intention of a deceased parent?
So answering your question first, Your Honor, yes, the Manaski has said that the intentions of caregiving parents are relevant considerations, and that has not changed. And the Fourth Circuit has lots of precedent about this, and our understanding of the record, Judge Quattlebaum, is that the mother said that she had an intent to take the child away, to come to the United States and take her back to Africa or what have you. But that is only part of the analysis, because here you have no parent coming in and seeking permanent employment or residency in the United States. And the fact that you have non-parents without rights of custody trying to establish a habitual residence of this child where they have no rights, our court here in the Rodriguez decision has affirmed that a parent cannot create a new habitual residence by wrongfully retaining a child. And so the fact that we have these non-parents trying to do so in this case should mean, we believe, that there's no wrongful retention or habitual residence in the wrongful retention analysis.
But can I ask you
could you answer Judge Berner's question? I think she said, do we care, or is it not, care is not the right word, is it relevant, what a deceased parent's intentions may have been, prior to the wrongful retention?
Yes, Your Honor, and I think both us and my friend would agree that is very relevant. Typically, as these cases develop, you look at that intent, and in other cases, the intent, they differ quite drastically. But in this case, both parents agreed and the appellees agreed that this visit was supposed to be temporary. Regardless of where she would end up eventually, it was here in the United States.
So can I ask you one more question about habitual residence, and then I have a couple on grave risk. So on habitual residence, so your friend represents in their brief that they're not aware of, quote, any published decision post-Manaski that has ever reversed a trial court's habitual residence determination. Are you aware of any published decision post-Manaski that has reversed a trial court's habitual residence determination?
No, I'm not, Your Honor, but I would say that it doesn't mean it can't happen, and it's only been, 5 years since that decision. So case law is catching up, and this is a perfect example of where it would apply.
Okay, so let's skip to grave risk. I understand the way I read the Hague Convention is that even if some defenses are made out, the Hague Convention says, essentially, the court can still say, yeah, I know that defense is made out, but I'm still going to send the child back to France. The convention contemplates the court's ability to do that. Do you know any court that has ever actually ordered the child back to the other country after finding the grave risk defense applies?
Not that I can think offhand, Your Honor.
And do you know any appellate court that's ever reversed a trial court for not sending the child back if the trial court correctly concluded that the grave risk defense applies?
I'm not, Your Honor.
Okay, so let's talk about the grave risk defense. Why is it? I mean, look. Let me posit that you make some excellent points in your brief about why a reasonable fact finder might have resolved this issue the other way. I'm less convinced that you've shown it's clearly erroneous, particularly given the, I mean, you know, there's deference, and then there's the deference that the Supreme Court has said that we give to trial courts' credibility determinations. And the trial court finds over and over again that certain things are credible or not credible. I guess I'd like you to just take a shot at persuading me that, not that it's wrong, not that it's really wrong, but that it is so wrong we can overcome the near complete deference we give to trial courts about credibility determinations.
Yes, Your Honor. And on that note, I'll note that United States versus Ali from this court says that when you have a clear and convincing evidence standard, which you need in order to prove grave risk, you have to have an abiding conviction that that the ultimate determinations raised in the contentions are highly probable. And based on our review of the evidence, which for the grave risk analysis, it's cabined to this 27-minute internally, we believe, inconsistent interview, where we have constantly internally inconsistent statements, suggestive and leading prompts by the interviewer. We have failure to distinguish between different actors and parties and parents and extended family members. We have admissions of adult influence, such as telling the child what to say, timeline and possibilities about when the abuse allegedly occurred. We have no sensory detail follow-up questions. We also have no corroboration from law enforcement. This court actually, in the case of Nolan versus Nolan, affirmed a district court's opinion where there were 43 different play sessions that lasted 45 minutes long each, where each time the child repetitively said, "My father abused me in certain very bad ways." And despite that, the judge below found there was no grave risk because of the internally...
Wait. So you're telling me that in a different case involving different facts, the trial court made the other finding and we affirmed it. I don't understand how that has anything to do with whether we should reverse this trial court's finding.
Which is just to say, Your Honor, that in the other case, the evidence was so high in favor of grave risk. Whereas here, given the inconsistencies, given all of the stuff that we pointed out today and in our brief, it should not and does not raise to that extremely high clear and convincing standard, which we believe warrants the reversal in that context. In addition to the fact that Miller from this court holds that when the courts of the abducted from country are ready and willing to protect the child, there is no grave risk. And the district court expressly found in her order that the French authorities were able and capable of doing so, and yet she found grave risk anyway. And Golan from the United States Supreme Court doesn't change that analysis, because all Golan says is once you find grave risk, you don't have to fashion ameliorative measures. But it doesn't change the threshold analysis of whether grave risk exists in the first place, because the child's home country can protect her during pendent custody proceedings.
Okay, Counselor, your time's, we've passed your time, but hold on, I want to make sure Judge Heitens and Judge Berner don't have any other questions before we move. Okay, thank you. You have some time on rebuttal.
Thank you.
Mr. Gary, I think we have the clock set at 20, so you should be good to go. We'll hear from you now.
Thank you, and may it please the court. I'm Matt Gary of Morvillo Abramowitz, and we're appellate counsel for the appellee, the aunt, uncle, and grandmother with whom the child has lived since June of 2022. This court should affirm the district court's exercise of discretion in refusing to uproot the child from South Carolina. The district court ruled against the appellant on 3 separate issues, each of which, standing alone, supports denial of the father's Hague petition. First, the district court was correct in finding that the father failed to establish a prima facie case. The Hague Convention therefore does not even apply. Second, the district court properly exercised its discretion in finding that the child was well settled in South Carolina. And third, The district court properly exercised its discretion in declining to send the child to France in light of the grave risk of harm demonstrated by clear and convincing evidence at trial. The district court.
Can I pick up on the Hague Convention doesn't even apply? Because I have a different question related to that. So you said that your clients are the child's grandparent, aunt, and uncle. Is that correct?
That's correct, Your Honor.
Have your clients ever gotten a child custody order?
So we
From
are
any
not.
court?
My understanding is that there are child custody proceedings underway in South Carolina after this Hague decision was made.
So can I ask what may sound like a sort of impertinent question? Why isn't this just a straight up kidnapping? Like, I don't.
A straight up kid.
Yeah, well, so let me just understand.
Please.
This child has two parents. Those two parents have both legal custody over the child. Those two parents agree to send that child to South Carolina. Well, one of them gets medical treatment. One of the parents dies. At this point, the child's only legal custodian is her father. Her father says, give the child back. And the relatives don't. I don't know under what legal authority. The Hague Convention is the classic situation where, like, I'm just going to use the gender terms, like mom and dad don't agree where the child should be, and one of them spirits the child back to the United States, and the parents disagree. But here there's no parent on the other side. We just have a child that has a parent who says, I want her to be in France, and some people who, let me posit, probably love the child and have been involved in the child's life, but from the perspective of the law, are some random people in terms of visa. Unless you get a child custody order, these are some random people who are refusing to turn over the child to the child's father. I don't understand how this isn't an abduction or a kidnapping absent a child custody order.
Well, first of all Hague Convention cases concern abductions, right?
Yes,
that's
but
the nature
almost all Hague Convention cases involve a situation in which two people, both of whom have legal rights to be involved in the child's life, don't agree. This case doesn't, at least unless there's a child custody order.
That's correct. That we're dealing with a situation in which there's one biological parent, the other biological parent has died, but the facts of this case are fairly unusual, and there is testimony in the record from the aunt that the mother actually said to her, I don't want this child to go back living with the father. I want the child to either continue.
Okay,
living
but
in the
admittedly,
United
it's been a long time since I've taken family law. But again, with grave sympathy and respect to the fact that the mother has passed, if there are two custodial parents, one of whom dies, the wishes of the deceased custodial parent are legally irrelevant at that point. Like, maybe the father should take that into account and give it very significant consideration and try to respect the late mother's wishes. But in terms of, like, legal power to decide where the child will be, once the parent one dies, I don't know why that person's wishes have any legal significance whatsoever.
Well, I think probably this actually comes back to the elements of a prima facie case under the Hague Convention, which is, that there's an alleged wrongful retention or removal. And
I guess I don't know the theory in which
habitual...
this isn't wrongful. I guess wrongful retention. I guess I just don't understand. Again, let's say that the father I imagine this wouldn't work because of his economic situation. But if he just went to South Carolina, went to the child's school, checked her out of school, and brought her back to France, I don't think your clients would have any assertion that he's done anything illegal at that moment.
That's an interesting hypothetical, but the question always comes back to what is the habitual residence of the child, right? And here we have a court finding that the habitual residence of the child is in South Carolina. And so I guess what I would say is the father's ability to exercise his custodial rights is cabined by the question of where the child's habitual residence actually is. Because the district court found that the child's habitual residence is in South Carolina rather than France.
I just think that's deeply wrong too. Like, let's say that I'm a single father who is raising my child somewhere and I need to go somewhere for work. And I send the child to live with their grandparents for 6 months. And then at some point, the grandparents decide they don't want to give the child back. And they say, well, the child's really well settled in Wisconsin, which is where I grew up and my parents live. Like, no, I'm the child's only legal custodian. We're not getting to any of these questions. I will let this go in a minute, but it just seems deeply, deeply, deeply strange to me because I don't even understand on what legal theory your clients even claim that it was not flagrantly illegal for them to not just turn this child over to its father when he demanded it.
Well, again, it comes back to the very limited nature of what a Hague Convention proceeding is, which is to determine where the child should physically be located pending custody proceedings. This is also a unique situation, right, where there are questions about whether or not the father, should appropriately continue to care for this child. And so that could be the subject of custody proceedings. I'm not super familiar with family law. I'm sure this is not the first time in which, one parent has died, another parent, is accused of abusing the child, and so other family members sort of intervene and take custody of the
But
children.
under that theory, the district court de facto turned the Hague Convention proceedings into a custodial determination.
I don't believe so. I think what the district court did was say that the child was not habitually resident in France at the time of the alleged wrongful retention. She did not make a determination as to custody. She made a determination as to where the child should be located, pending whichever custody proceeding.
If the father then continues to be the sole custodial parent, and as Judge Heitens pointed out, the relatives that you represent are legal strangers to the child, then on what basis would your clients even be able to go into court to seek a custody determination? Frankly, I don't even know how your clients approve of medical decisions on behalf of the child or continue to enroll the child in school. They are legal, as far as I understand it, they're legal strangers to the child, and they would have no authority to make those kinds of determinations once consent had been withdrawn from the sole custodial parent.
So those are questions of family law that are just not before the district court in making a Hague Convention determination. It's a very, very narrow claim. It's a very, very narrow case. Whether or not the aunt and uncle and grandmother are sort of appropriately, approving for medical care and things like that is not something that the district court gets into. They're just limiting their analysis to a question of where the child's habitual residence is. And if finding, that the child's habitual residence is in France rather than South Carolina, whether or not certain affirmative defenses justify keeping the child in South Carolina pending whatever custody proceedings would take place in France.
Okay, so let's talk about what the district court said. Why is your friend on the other side not just stone bang right that whether it's habitual residence or well settled, the district court fundamentally erred by talking about things that post-date the last plausible wrongful retention date? Like how the child is doing in school today, the fact that the child has a lot of friends today, the fact that it was difficult at first, but she's doing a lot better now. I mean, I bracket the point that the other side is a little shifty about when exactly the wrongful retention is, but I think we can all agree that it was at some point, and it wasn't last fall, right? I think at some point well before last fall, it became unambiguously wrongful. And yet I see the district court talking about how she's doing in school today. That's just legally wrong, isn't it?
It's not legally wrong with respect to the well-settled defense. For habitual residence, that question is determined at the time of the alleged wrongful retention. But when examining whether or not the child is well-settled, which is an affirmative defense, you're actually sort of asking what's going on today. Because the purpose of that affirmative defense is to say, okay, well, somebody sort of sat on their rights. They didn't file a petition within 1 year of the retention. And although they may in some sense be entitled because they've made out the prima facie case to have this child returned, you start to worry that uprooting the child's life will do more harm than good.
That's fair enough. So let me modify the question. You agree that to the extent I read the district court as having considered recent events for habitual residence, that was wrong.
I don't read the district court's opinion that way.
I said if I read it that way.
Yeah. So if you read it that way, the district court should not consider evidence past the date of the alleged wrongful retention. Again, that kind of comes back into this problem that we have of when did that wrongful retention actually occur. But I think if you read the district court's opinion, you will see that she says even 14 or 15 months is sufficient. She cites to a District of Colorado case to that effect. I think that she is in some ways targeting the late summer, fall of 2023 in conducting habitual residence analysis, because otherwise she wouldn't have said even 14 or 15 months, right? The child went to South Carolina in June of 2022, and then 14 months later, we're in October 2023. So I do think that the district court appropriately cabined the habitual residence analysis to, as you sort of put it, like any plausible time that the alleged retention could have occurred. But, in setting forth her findings of facts, those findings of facts can also support the well-settled defense, and those can go, right up until the date of the decision. And so, while she did not necessarily cut that distinction in her analysis, I think it is clear from the way that she was phrasing things that she was cutting that distinction in her decision. So if you would like, I can move on to the grave risk if there aren't further questions about habitual residence or well settled. I think the major issue that my friend faces is that the grave risk defense depends on a completely separate and independent body of factual findings made by the district court here. And the district court considered numerous sources of evidence, including the forensic interview of the child, which the appellant stipulated would serve as the child's testimony in this case. She considered testimony from the aunt, who also testified that she witnessed several incidents sort of on a video call of the father physically abusing the child. So it's not as if that forensic interview is the only source of evidence for alleged abuse. She also considered the lack of credibility of the appellant himself. He categorically denied ever, washing, bathing, whatever the language that it is, that he ever bathed a child. And his own witness that he called in his defense said, well, actually, the father bathed the child while the mother was sick. And so he completely undercut his credibility. It's very clear that that shot his credibility in the eyes of the district court. And so her factual findings in terms of the grave risk analysis is not simply just, well, I watched the forensic interview and I believe the child. That is a big component of it. But there were other factors at play, including the lack of credibility of the father and the testimony that she credited from the aunt. They really are just trying to nitpick what goes on in the forensic interview. They actually called a blind expert to testify sort of in generalities about the proper way to conduct a forensic interview. And the district court found that based on the expert testimony, she did not see anything that made the forensic interview that she observed inadequate. There is not, indicia of coaching. There is some confusion that is clarified in the forensic interview where the child sometimes says, oh, my mom, but she really means her aunt. And then she later clarifies and says, oh, I'm talking about my aunt here. But that's not something that's injected by the forensic interviewer. That's something that's confusion that's caused by the child herself. And I think kind of sort of gives away who she's used as her caretakers here. I mean, she's so embedded in South Carolina at this point that she's calling her aunt and uncle mother and father. I think the appellant is trying to turn that on its head and make it sound like there was some kind of manipulation going on and that there was some scheme to sort of steal this child. But I think it's a reflection of the fact that after the father sent this kid to South Carolina, he didn't really engage with her anymore. He didn't provide financial support. He didn't send birthday cards or Christmas presents. And he didn't even really call her. And the judge found, as a matter of fact, that the father could interact with the child, could contact her if he wanted to, but he didn't. And so I think the forensic interview demonstrates
counsel,
both.
all of the arguments you're making seem to more appropriately go to the custody determination rather than a Hague Convention determination. But on the question of grave risk, your friend points out that the district court did say that the French justice system would be adequately equipped to protect the child and to conduct a proceeding regarding these allegations of abuse. Why is it not then appropriate, given that finding, to have the French justice system determine whether or not these allegations of abuse are indeed credible?
Two reasons. One is I think if you look at Van de Sand versus Van de Sand, which is the Seventh Circuit case, they take a very pragmatic approach to grave issues of grave risk, which is upon finding that a grave risk exists of this sort of physical or sexual abuse, it's unrealistic to assume that authorities will be able to prevent it from happening again. We're talking about things that are happening behind closed doors, and so it's sort of unrealistic to say, well, the French have good laws or they take this kind of stuff seriously, and so let's just roll the dice and send the kid back and see what happens. I don't think that a district court is required upon finding that, a certain country has a legal system that would protect against these kinds of things in the abstract, must therefore send the child back upon finding a grave risk. I think further, Golan undercuts those arguments, although Golan doesn't address this particular sort of aspect that of whether or not a country has a system that's designed to prevent these sort of things. They do talk about ameliorative measures, which I think are conceptually very similar to the analysis of what a court has in terms of, well, does France, protect against these kinds of things? It's about mitigation. It's about prevention. And in Golan, the Supreme Court says district courts are not required to consider ameliorative measures. They're not required to consider things that could be done to mitigate or prevent these types of grave risks from reoccurring. And they specifically reference, physical and sexual abuse as the type of situation in which a district court can properly decline to consider those types of measures. And so I don't believe that those types of considerations necessarily mean that a district court has to send a child back to their country of origin upon finding a grave risk. And if there are no further questions, I am happy to rest on my paper.
Good. Judge Heitens, do you have any other questions? Judge Berner? Thank you, counsel.
Your Honor, Matt Avey of Bell Smallins, also here on behalf of the petitioner. Judge Hayden, let me jump to one of your questions that you had as far as the communication of the request for return to the respondent. So the judge's order on Joint Appendix 120 cites to the guide for judges and says that in a wrongful retention case, there are two scenarios in which the date can be determined. It's either where it is communicated to the respondents or the abductors, in this case the respondents, make unequivocal showings that they're not going to return the child. And there's nothing that requires a date certain for those actions, but it is an either or. And so in this case, we have both scenarios. We have both the fact that he communicated on the 14th and the 20th of 2023, but then we also have the admission.
Wait, so these, just to be clear, the 14th and 20th, these are the October calls?
Correct. Those are the phone calls from
for which, just be clear, for which literally all we have is your client's own unadorned testimony that happened and no corroborating evidence whatsoever?
That is correct, Your Honor.
And doesn't the district judge say, like, it's kind of weird that dad says he made these phone calls, but there's literally no evidence of them at all?
I agree with you.
And how could a district judge clearly err in saying, I'm not, with all respect, going to take your client's uncorroborated word for when he did this?
I certainly understand your point, but our fallback to that is, Your Honor, that even if you don't trust those dates, you don't trust the 14th and the 20th, you have the 27th, and that date is set. And it's an either or, so it doesn't have to necessarily be the communication. It can also be the unequivocal respondents not wanting to return.
So, counsel, if I could stop you, let's go with what you just said, that the October 27th date. Let's assume that's a date that that the retention becomes wrongful. Do we then look to the period before that to determine the habitual residence of the child? Is that the next legal step we do?
That is correct, and it was error for the trial court to consider anything after, and the trial court very clearly did by considering the school records, the English proficiency at the time of trial, the fact that the child had friends at the time of trial. So
let me, before I get to that, address the good question Judge Heitens and Judge Berner mentioned about whether that the grandmother and aunt would have had any sort of custodial rights. Under the Hague Convention law, I mean, is it, tell me if this is correct or incorrect. They may or may not have custodial rights, at being that one parent died and one survives. But under the Hague Convention, if the wrongful retention is October 27th, that means that the father had not established that it was wrongful for the child to be there before then. And we would look to whether the district court was right in deciding whether the child was habitually residing there prior to October 27th. In other words, I guess I'm asking you this: could the child be habitually residing in South Carolina prior to October 27th if with two relatives who are not parents?
No, Your Honor, and that
Are you
is
saying as a matter of law that because that there is no, because you what you said right before I asked you was that the district court looked at evidence after October 27th. That's one thing. It seems to be now you're saying there's no way whatsoever that two relatives that the father had at some point agreed for these to be, keeping the child. It's no way that there's no way as a matter of law that the child could have habitually resided there. Is that what you're saying?
I under these facts, correct, and under the Fourth Circuit, this court's precedent in Rodriguez, which
What are those
says
facts? Tell me what those facts are.
well, the facts are here that the child came to the United States with the consent for a transitory period, and then after that was asked to be returned. And so the fact that it's a transitory period, even under Manaski, means that you do not create the new habitual residence.
How long is there a period? I mean, that makes sense to me. Certainly, the way this started out, but it continued, for I guess at least over a year until October 27th. And I know your client disagrees and said he checked in and tried to get the child, sent back before, but the district court looked at evidence that found that uncredible. So I guess I'm trying to figure out, can what might have been an initial transitory period, kind of progress into something that's not and becomes habitual residence? Is that like impossible as a matter of law?
No, Your Honor, it's not impossible as a matter of law. However, that's not the facts of the case here. Everybody agrees that the child was intended to return once mother's treatment ended. Even the respondents agree to that. Now, there is some evidence in the record where the respondents claim that the mother called and said that she wanted to take the child back to Africa, didn't want to take the child back to France. But that doesn't mean that South Carolina becomes the child's habitual residence. And so under these facts and under the principle in Rodriguez from this court that you cannot create a new habitual residence by wrongfully retaining the child, that means that the habitual residence is France. And that's, if I can sum up this point, and the overarching point of this case, which is the Hague Convention's purposes would be advanced by returning this child to France. The Hague Convention itself is founded on principles of internation trust and on comity. And the other countries have to trust that the United States, even in the tough cases, is going to enforce the return remedy where it needs to enforce it. And this is one such case where the district court has erred as a matter of law, both in finding that France was not the child's habitual residence and in refusing, after a finding of grave risk, which we believe rests on shaky grounds, in refusing to consider ameliorative measures that were properly presented to the district court and just not even addressed in the district court's opinion. So as a result of that, we'd ask that the court reverse, enter judgment for the petitioner, and remand for a decision on the prompt return or the logistics of the prompt return of the child to France.
Thank you, counsel. Judge Heitens, Judge Berner, do y'all have any other questions? We appreciate both of y'all's arguments in this, difficult case and helping us, to address this issue. Normally I forgot to say this to the first lawyers, but one of the traditions of our court is that we come down and greet y'all in person. We, obviously can't do that physically, but please, please accept our thanks for presenting these arguments to us and helping us decide this case.
Thank you, Your Honors.
Okay, Judge Heitens, Judge Bernard, are y'all good to go to the next case, or would y'all like to take a break?
Could we take 5?
Sure, sure. Sarah, will you
Okay,
kind of,
thanks.
if we'll take a 5-minute break and we'll come back and then go to the next case?
This honorable court will take a brief recess.
before we hear from the appellant, let me just make sure we're all under the same understanding of how we're proceeding in light of the sealed information. I hope you received the order. What we're going to do is bifurcate that. I know that wasn't everyone's preference, but that's what we're going to do. So we'll go with the 16, 4, 20 time periods, and then we'll give each side an additional 5 minutes. After we do that, we'll take a little break and seal the record electronically and consider any matters that need to be heard under that context, if any, at that point. So, and I know the parties are cognizant of this. We'll try to be so as well, but don't hesitate, either of you, to interrupt. At least me. I mean, I know that's normally not what you feel comfortable doing with judges, but we don't want to cross that line. If you think we have, it won't bother any of us for you to interrupt and say something.
Thank you, Your Honor.
Okay, with that, we'll hear from the appellant.
Thank you, Your Honor. May it please the court. My name is Mike Piccini, Goodell, DeVries, Leach and Dam, Baltimore, Maryland. I represent the appellant, Kieran Andrews. Mr. Andrews was the subject of a warrantless search for his cell phone and ultimate seizure of that cell phone by the Baltimore Police Department. The lower court failed either to understand or ignored the actual technology being used here and what it was doing. Mr. Andrews was, yes, a fugitive from justice. He was wanted on an arrest warrant, and they were having trouble finding him. So instead of seeking a warrant under the Fourth Amendment, which would allow them to use the technology that they used in this situation, they sought something called a pen register order. A pen register order, and the pen register order here at issue included an order for 60 days that they were going to use a pen register trap and trace device or a cellular tracking device, which is not defined in any of the statutes with regard to the pen register order. The problem with the PRO is that and Your Honor, appellants understand that the Fourth Amendment doesn't require that, with particularity, the police, the government tells you exactly how and what they're going to do. But it should at least require that it tell you that it is going to seize a specific piece of personal property. And that is what happened here, because what has been admitted in Appellee's argument is that what this technology does, and I hope that I am not going beyond what we are supposed to be discussing at this point, is it basically sends a very powerful electronic signal out. That electronic signal is powerful enough to pierce through the walls of private residences. That electronic signal is powerful enough to cause every telephone on that specific network signal that the technology is using at the time to connect to that technology. And it may connect to it for only a second or two, identifying what that specific telephone is. In this instance case, the technology was set to look for one specific telephone.
Hey, counsel, could you on my screen at least, there is a window that's popped up. I don't know if that's other people are seeing that.
No idea, Your Honor.
Okay, well, it may just be South Carolina goblins who infected things. But anyway, if you could proceed. I'm sorry for interrupting you.
And no problem, Your Honor. I am as technologically unsavvy as the next person. Where was I? Yes, so this court had looked at this before and had very serious qualms about whether or not, and now I see the window has popped up over top of the timer. So I'm not really sure. I'm just seeing the last second of the timer. Now it's gone. This court had 6 questions with regard to the capabilities of the technology at issue. We certainly won't get into those questions, but we went through discovery over a long period of time. Unfortunately, it was truncated by COVID. And we found that there was information about what this technology can do. And it was, but besides that, and so that we don't get into areas that should be sealed, what the court below fails to realize here is that the PRO could not possibly have acted as a good faith warrant because it doesn't need to name the technology being used, but it certainly needs to tell you what that technology is going to do. And all the PRO does is say that what they are seeking to do is install something on Mr. Andrews' phone. A pen register is installed on the phone, and the phone operates, because otherwise the pen register wouldn't work. A trap and trace device is installed on the phone, and the phone continues to operate as a phone.
So, counsel, let me get you on that. I think one of the arguments you're making is that aside from what happened afterwards, that this warrant, this PRO was not a valid warrant that would have allowed this. And as I understand the record, it certainly is the form that is used and for pen register, orders. And I get that point, but I'm having trouble understanding why the language itself doesn't, at least in a general sense, describe what happens here. I mean, it talks about to employ duplication of facilities. It talks about, the installation and use. And so if you look at use, it talks about a cellular tracking device. It talks about initiating a signal to determine the location of a subject's mobile phone device. I don't think a pen register does that. Maybe I'm wrong there. And then it goes through some other language and talks about any and all locations. So I appreciate how this might typically be used for a PRTT order, but I'm wondering why the language doesn't describe what happened here.
Thank you, Your Honor. Nothing was installed on Mr. Andrews' phone.
Okay.
Mr. Andrews' phone was basically seized. During the time, and this is admitted in Appellee's papers, we have argued that what this technology does is render the telephone, when used in this way, inoperable for anything other than what it was used for, to find Mr. Andrews. Appellees note in their papers that, well, it can't connect if he's on a call, and it can't connect if he's dialing 911. So it obviously knows that, but they then don't say, after it has connected, can he make a phone call? Can he call 911? Is his phone still in his possession when this is attached to it and used in the manner it was being used? And the answer, given what we have, is no. The phone is rendered inoperable except for its use as a location device now in control of the government. And that is the fatal flaw of the PRO here. The PRO goes and says, yes, we're going to do this, and we're going to do this, and we're going to do this, and then stops short by not saying, and we're going to take the phone and make it useless. Because that is, now, I'm sure that my friend will argue that, on Wi-Fi, it will be fine. Well, on Wi-Fi, that still does not mean that it can make a phone call. It does not mean that the phone is actually still in Mr. Andrews' possession. He was in a private residence at the time, a place the Fourth Amendment recognizes as a reasonable area of privacy. He had in his possession his personal phone. And while in his possession, the phone was literally taken out of his control.
Can I ask you to jump ahead to a couple questions that, at least for me, importantly frame this case.
Certainly.
How in the world are the individual officers not entitled to qualified immunity? The Second Circuit had a case that was extraordinarily similar to this one several years ago and said, wow, there's like no clearly established law about literally any of this. And what happened here happened 2 years before that Seventh Circuit decision. So I really don't understand what the plausible argument would be that these individual officers don't have qualified immunity.
Well, Your Honor, what we'd say about the qualified immunity is that in their papers and in the evidence, the officers admit that they knew that this was a signal that was sent that would go through walls.
Okay, now I'm going to tell you that under the Fourth Amendment, under Harlow versus Fitzgerald, I literally don't care what these individual officers knew.
Okay. Well, whether they knew or not, Officer Haley has testified that he understood the technology at issue. It has been taken as gospel that using the word cellular tracking device means a cell site simulator, and that everyone involved knew that it meant a cell site simulator. Does that mean that everyone involved knew what a cell site simulator does?
No, does that mean that at the time that's relevant in question, would every single police officer, reasonable police officer, know that what they're doing here violates the Fourth Amendment? And I don't see any plausible argument that they would have.
I believe they should because of Kylo, Your Honor. How can you possibly turn on something electronic?
Because Kylo says you have to get a warrant, and these officers did something that, I guess I'll posit, at least a reasonable officer could believe complied with the Fourth Amendment's warrant requirement.
We don't see that this is a reasonable application of the Fourth Amendment because of the very fact that what this, and this is probably our hardest argument, I will admit, Your Honor, but the qualified immunity here, at some point we're counting the angels dancing on the head of a pin. They either know that what they're doing requires a warrant or they don't. Simply because the technology is new doesn't give carte blanche to then just believe what one is told. These are in their affidavit and in their PRO. They talk about their experience. They talk about how they know this, they know that, they know. Why don't they know that simply turning on a piece of equipment that is going to pierce the walls is somehow not required doesn't require a warrant?
Counsel, just to interrupt you, I mean, I understand that argument, and it may be successful that this, technology does go inside a wall, but it seems to me there's at least, there's the issue of, is this a sufficient warrant? You have an argument that it's not, but that there's language that might suggest it is in the warrant. There's Carpenter, which has some language that I think helps both of y'all, even though none of you talk much about third-party consent here. You mentioned the Kylo case, and I appreciate that may help you, but the Jones and the Caro case, I think, have some language about tracking devices, and this might be analogous to that. And I'm not saying those ultimately prevail, but I think that gets to Judge Hyten's question is we don't have anything that talks about this. We got the Supreme Court recently saying, I'm expressly not addressing real-time information. How could it be clearly established?
Your Honor, it's clearly established that you have a reasonable expectation of privacy into where you are if you're in a private residence.
Is that true for a fugitive there's a arrest warrant out for?
Unfortunately, I believe it is true for a fugitive who has an arrest warrant out for him. They certainly don't give up their rights to privacy simply because they have an arrest warrant out for them. And they certainly don't lose their Fourth Amendment rights because there is an arrest warrant out for them. The problem that we think is fatal for this warrant PRO is not that mentioning of cell site simulator, not that the technology is so far reaching and unknown. the officers knew what was going to be done. They knew that they had been using a PRO, and this, I'll take this to the Monell argument. There was, in fact, a procedure, an informal procedure in place to not discuss the cell site simulator. That was to use a PRO and call it a cellular tracking device. Now, a cellular tracking device, and the way the way that the PRO reads, it reads as if, again, I hate to sound like a broken record, but we're going to put a tracking device on the phone. We're not going to, but what they did is turn the phone into a tracking device. They didn't put something on the phone to make it able to be followed. They turned the phone literally into the state's tracking device.
Can I ask you about the Manel issue? So, as I understand it, in order to prevail against the city, you'd have to show that there was a policy or custom of the municipality that was the moving force behind the constitutional violation. It seems to me that if there was a constitutional violation here, it's one of two places. Either A, it's not obtaining something that's a warrant within the meaning of the Fourth Amendment, that's arguably a constitutional violation, or B, it's that the thing you got, even if it is a Fourth Amendment warrant, is insufficiently particularized or doesn't meet the requirements of a valid Fourth Amendment warrant. It seems to me that the constitutional violation has to be one of those two things. And I don't understand how this NDA policy is the moving force of either of those violations. It doesn't say you're not allowed to go get a warrant. It doesn't say that. And nor does it say, if you get a warrant, the warrant can't be sufficiently particularized to comply with the Fourth Amendment. So I guess I just don't understand how the NDA is plausibly the moving force behind any plausible constitutional violation here.
Your Honor, the NDA is the entire reason that a warrant wasn't sought. Because
And I know that because
they sought the PRO and instead of a warrant. They tried to fit a square peg into a round hole because they could not go to the court and be forthright and honest about exactly what they were going to do.
You don't allege the NDA policy said you can't ask for a warrant. There's nothing in the NDA policy that says you can't go to the judicialiest judicial officer in the world and ask for the most Fourth Amendment warrant in the world. There's nothing in the policy that says you're not allowed to do that, right?
As far as I know, there is nothing that prevents them from doing that, but there is something that says that they should either drop the case or not proceed with it so that they don't have to, somehow out this technology. But when you take the NDA in conjunction with the fact that they use a PRO which does not address the technology and then adds this synonym for cell site simulator, they have attempted to at least try to get some type of an order here, but it was fatally flawed in that it did not explain to the court not exactly what they were going to do, but the far-reaching of what was the end result here. Not that they were going to install something that would assist them in locating Mr. Andrews, but that they would take something in Mr. Andrews' possession and turn it into that thing that will be able to lead to him.
Okay. Counsel, thank you. You got some time for rebuttal before we go into the sealed portion. Thank you very much, and we'll hear now from your colleague, Ms. Amato.
Morning, and may it please the court. My name is Natalie Amato, and I, along with my colleague Brent Schubert, represent the appellees, the Baltimore Police Department, former Commissioner Kevin Davis, and Detectives John Haley and Michael Spinato. The Fourth Amendment requires striking an appropriate balance between the interests of the government, including public safety, and protecting against arbitrary infringements on an individual's rights. That balance is subject to the Fourth Amendment's broad command of reasonableness. On remand, the parties were asked to conduct fact-finding on several specific questions. The material facts, supported by a detailed evidentiary record, demonstrate that appellee's actions were reasonable and constitutional. We ask this court to affirm Judge Gallagher's opinion.
The threshold question that really confused the heck out of me when I first read Judge Gallagher's opinions. So I'm looking at our previous order in this case, and we remanded for the district court to make factual findings, and then I'm confronted with the district court order that grants summary judgment, and as someone who used to teach civil procedure, the first rule of summary judgment is that you don't get to make factual findings when ruling on a motion for summary judgment. So why in the world did your client, because I checked who did, why in the world did your client think it was appropriate to move for summary judgment after we've remanded for factual findings?
Your Honor, thank you for that question. I agree that the procedural posture of this case is a little bit odd. Judge Blake had asked for factual findings, so there was a factual brief that was submitted, and then she asked for updated positions on the law. So I believe that that motion for summary judgment was an attempt to provide the updated findings and our conclusions, because Judge Blake's order.
My Civ Pro 101 that you don't make factual findings when you rule on a summary judgment motion?
Well, she was entitled to say that there were no material facts in dispute, and given
Sure, but that's not what we told the district court to do. We told the district court to make factual findings.
Is that right? I mean, it does, certainly we did that, but didn't we also say, and any, conclusions of law?
That is correct. The remand order said to make factual findings and updated conclusions of law as appropriate. And I believe that's Judge Gallagher interpreted the order that way, and also attempted to synthesize a very detailed and robust evidentiary record. Your Honor, I had intended to start with the remand questions specifically, but as they deal with the cell site simulator's functionality, and given the recent order, I'm going to start with other issues in the case, which are actually the issues that you had a lot of questions for Mr. Piccini on. So as the court is aware, it is unsettled whether the location of Mr. Andrews' phone using a cell site simulator constituted a search or a seizure. Neither the Supreme Court nor this circuit has squarely decided this issue.
Except you repeatedly conceded that fact before the district court and during our previous appeal, and even in your current briefs, you don't actually argue it's not, you just reserve the right, which I also don't understand, because that seems like a fundamental violation of civil and appellate litigation 101. The time to make the argument is now. It's not to say we'd like to preserve our ability to make an argument that we've never made before.
Your Honor, I was actually just about to say that we had previously conceded only for the sake of argument, though. If you go through the record, you'll see that the motion to dismiss and the alternative summary judgment in 2017, that's at JA 51, we said it was only for the sake of argument. And that was because Judge Blake, in a hearing,
Well, counsel, does it really matter if you conceded it? If you concede it, you concede it. You can't concede it and then argue against it. I mean, at some point we gotta, go with your concessions unless you formally withdraw them. I guess we could look at that. But I mean, why are we talking about something, even if it might be a good argument, that you've conceded for purposes of argument?
Well, Your Honors can decide the case on any issue that you wish to, and apply any doctrine of Fourth Amendment jurisprudence that you choose to, including the third-party doctrine if you chose to do that. But frankly, the record is very...
How can we do that without violating the mandate rule? I'm literally looking at our previous opinion in this case. Defendants concede that the hailstorm simulator searched, at minimum, Andrew's phone, and that its use thus required a warrant. That is a statement by this court and a published opinion in this case.
Respectfully, Your Honors, we don't agree that that remand order accurately reflected the record.
Judge Blake... Then the answer is file a motion for rehearing or for us to correct our order because we've misunderstood what you said. But there's a published opinion of this court that says you conceded it.
And I hear Your Honor on that point. We reserved our right in an abundance of caution, and we were asked by Judge Blake to assume, for the sake of argument, that it was a search. And so I think that's sort of...
Well, counsel, you got 15 more minutes, and if you want to argue things you conceded, that's your prerogative. But, a more helpful thing, I would just encourage you to, help us with things that you hadn't conceded as well. But it's your time. Use it however you want to.
So, assuming it was a search, Judge Gallagher and Judge Blake correctly held that there was a valid court order that was the functional equivalent of a warrant to locate Andrews' phone. Whether a document is called a warrant or an order is not material so long as it satisfies the mandate of the Fourth Amendment. Andrews' attempt to subject this warrant to, in this case, to a hyper-technical, non-common sense review must be rejected. As this court explained in United States versus Srivastava, The contents and scope of a warrant and its supporting affidavits must be evaluated in a common sense and realistic fashion, eschewing technical requirements of elaborate specificity. In Dahlia, the
Counsel,
Supreme...
If we were to agree with, let's just pause it for a moment, that we agree with you that a pro can be a warrant. In this particular case, what's the probable cause that the magistrate found in this pro, and how does that satisfy the probable cause requirement?
Your Honor, the probable cause was that the cell phone at issue was connected to the crime, and that that cell phone would lead to the location of Andrews.
Was the cell phone connected? How was the cell phone connected to the crime?
It was indeed, Your Honor. That was the cell phone number that was used to lure the victims to the location of the shooting. And that cell phone number was identified by the victims and corroborated by the cell phone records that were obtained. It was also independently corroborated by BPD's databases, and it was also corroborated by his CI handler at BPD. So there were multiple things that connected not only the phone to the crime at issue, but also to Mr. Andrews. So we believe there was a very solid basis for that Judge Williams had a substantial basis for the probable cause. And also as part of that, Judge Williams was aware that Mr. Andrews was eluding and that the officers had a valid arrest warrant to effectuate on him. I would also note that there's been some...
Wait, does there need to be any connection between the phone and the crime? Why isn't the probable cause, we have great reason to believe that this gentleman committed this crime. We have great reason to believe that this is that gentleman's cell phone account, and because of basic facts that every adult knows about the world in 2026, we have pretty good reason to believe his cell phone is probably somewhere near him.
So valid, Your Honor. That was all part of the probable cause analysis, and it's related to, he had probable cause to believe that location of the phone would lead to apprehension of this particular individual who was identified as being involved in the crime.
So, counsel, let's assume for argument you have probable cause and a valid warrant. Does that permit activity that that sends electronic signals into a residence?
Your Honor, in this instance, we believe that it does. That was specifically identified in the warrant, that it would initiate a signal. That is exactly what a cell site simulator does.
Well, does it matter? For sure, I mean, I think it does say that, but does it matter that the signal goes into a residence or not? Does that fact matter?
So I think there's two reasons why it does not matter in this case. I think the first reason is sort of is Kylo, which is that this technology does not reveal anything intimate about the home. It does not even reveal who's present inside the phone, just is inside the home, just where the phone is. It does not provide any reveal any intimate details about what goes on inside the home. And then the second is
let me respond on that one. I know you got another one, so I'll try to remember to to not forget that and give you time for sure. But I think there's a fair argument that the information obtained is different than you would get from the from the technology in Kylo, but it is something that would not have been observable from the public streets or the curtilage of the house. I mean, there's no question about that, number one. And number two, is it in some way a little bit more of an invasion of the home than Kylo because it's sending signals into the house as opposed to understanding or determining what the heat coming from the house means?
So I would argue that it is actually less invasive than Kylo. In there, they were targeting a specific home, and they were trying to find incriminating information, and the technology they were using was partly to detect that. Now, in this instance,
But why
phone was also.
why does that even matter? But in Kylo, the question was not whether you could use the technology. The question was whether you had to get a warrant to use the technology. So even if this
That's
is
correct.
as or more invasive than Kylo, all that suggests to me is that you have to get a warrant, not that you can't get a warrant to do it.
Warrant to do it. And in this instance, the information is much less intrusive. It's anonymous electronic identifiers. But also, Your Honor, I think with the cell phone, they are constantly throwing up their own signal. So this idea that it's just penetrating the home, I think that's sort of a misplaced argument. The phone itself is already acting to throw signals out, and those go the other way. They go outside the home. I mean, the Fourth Amendment jurisprudence also can't be so stuck as technology evolves of thinking of searches to just involve a physical place necessarily. The Fourth Amendment protects people, not places. And while it's still important, I think we have to be focused on what was actually sought here, which was a phone, which by its definition is mobile across the entire world. To the second argument that I was going to make is related to Peyton and Stegall and its progeny. You know, this phone could have been located anywhere. It could have been on a public street. It could have been in a home. It could have been in a business. But in this instance, there's nothing in the record. There's no evidence that Mr. Andrews had a privacy interest in that home. There was a proffer at the criminal court that was not under oath. He's never submitted an affidavit or anything to that effect. And so the officers had a warrant, and if they had a reasonable belief that he was present in that home, they were able to go in and effectuate that warrant. But they didn't just do that. They got consent to go inside. And when they located him in the living room, which was a common area, even if he'd had a privacy interest in that home, it was an interest that was diminished because he was located in a common area, and a co-resident allowed them consent, although we do not concede that he had a privacy interest.
Ms. Amato, what I
Yes,
hear you saying is that this technology was really used for the purpose of locating the individual rather than really for the purpose of continuing an ongoing investigation. And so, and really when I look at the application, I see nothing in the application that goes to your prior argument that the phone was used as part of the crime. There's really nothing in the application making that allegation. Really, the application talks about locating the individual. Do you have a case that supports what sounds like you're arguing is that it would be proper to use this technology to locate an individual as opposed to investigating a crime? And I don't see any cases that support that proposition.
So in the application, it does say that they were attempting to effectuate the warrant and locate the person and effectuate an apprehension, which is what the Fourth Amendment contemplates. But the Fourth Amendment also contemplates that you can look for evidence of a crime. And in this case, this phone happened to be both.
But the pro application doesn't talk about looking for evidence of a crime. It talks about looking for Mr. Andrews.
I mean, it does. It talks about how this phone number was connected to him and he was the shooter. This was, Judge Williams in this case had also
Can you tell me where exactly in the pro application it talks about continuing the investigation of the crime?
I'm not suggesting that they were continuing investigation of the crime. I'm just, under the Fourth Amendment, you can search for evidence of a crime.
I'm talking about this particular pro application. I read this pro application as applying for a pro to help in locating the individual.
So,
and if that's the case, do you have any support for your proposition that this technology may permissibly be used to locate an individual?
So this technology was used to locate a phone that was attached to a particular individual. The pro application does say investigators were able to obtain Mr. Andrews' cell phone number through the victim's cell phone number. Judge Williams had also approved other applications in this case that detailed the crime more thoroughly about the use of the phone during the shooting. But again, that's just a general Fourth Amendment principle that you can use a search warrant to search for evidence of a crime. You're right that the application was for this phone. That's what they did. There's no evidence that they obtained or accessed any content on this phone at any point. And there's no evidence that any content in his phone or any other party's phone was ever used against Mr. Andrews in the criminal trial, or even that they tried to do that. So, if Your Honor would permit me to move on to other matters, unless you have any other questions. So,
Yeah.
Your Honors, I believe that the Dahlia standard is also met here, as was discussed with Mr. Andrews' attorney. There was very specific detailing of the technology in the warrant itself. They did not exceed the scope of the warrant, and they did not withhold any information from the reviewing magistrate. There's no evidence that Judge Williams abandoned his role as a neutral and disinterested magistrate.
But let me preface this by saying that I'm not sure this matters under Virginia versus Moore, which I generally read to stand for the proposition that the Fourth Amendment doesn't care about what state law says. But it does seem strange, because you keep saying they got a warrant, 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 but actually they didn't, at least seemingly under Maryland law, get something, how one gets a warrant under Maryland law. Is there any explanation of why that is the case from your perspective in the record? And second of all, why shouldn't that at least, again, be troubling, even positing maybe that Virginia versus Moore says none of that matters?
When you say why that doesn't
You
matter,
keep saying today that it's a warrant, except that under Maryland law, as your friend represents, like there's a way to get a warrant, a thing called a warrant under Maryland law. And they didn't get a warrant; they got something called a PRO order, and they went to a different person, got a different order. Again, I'm willing to entertain the proposition that the Fourth Amendment ultimately doesn't care about that, but what's the non-bad explanation for why your friend represents, oh, I know why they did it. They were trying to avoid seeking a full-on warrant for some reason. And I guess I didn't see in your papers any plausible counter-narrative for why they did what they did here.
Green actually testified that part of the reason they went under the PRO statute was because that was the Maryland state statute that involved electronic devices at the time. And so in the absence of any clearly established law, they believed that would be the appropriate type of document to use. He also testified that Judge Williams was very involved in developing that document. And so I'm a little puzzled by your statement that they went to another judge. They didn't do that. They went to Judge Williams in this case for a warrant. And he also approves warrants. Judge Green specifically testified that in the spring legislative session, which would have happened before April of 2014, so before Andrews' location, Judge Williams was involved in the development of this document. So he was well aware of what was being asked for, and they were attempting to create a document. They were attempting to obtain an order supported by probable cause, which they believe was the functional equivalent of a warrant, in a way that would best describe the technology. And so I think that was the intention here. It's also been suggested that they did this to sort of go around the NDA. There's no evidence in this case that occurred. But even in their opening argument, when this case was heard back in 2020 in front of this circuit, they acknowledged that BPD had been using these applications since at least 2007. And so that attempt to sort of go around an NDA that was authored in 2011 is really unavailing. Here they tried to obtain what they thought was the appropriate document, and they tried to comply with the Fourth Amendment. They went above and beyond in describing the technology and what they intended to do, and they followed it, and they didn't exceed the scope. And Your Honor, I see that my time is about to elapse, so as long as there are no further questions, I would submit on my papers.
Judge Heitens, Judge Berner, do y'all have any other questions? No other questions. Thank you for your argument, counsel. Mr. Puccini, you have 4 minutes in rebuttal. I think you're on mute. You're on mute.
Sorry, Your Honor.
Well, I said you're on mute rather than mute, so you know I've been a judge too long when I mess those up. But anyway, go ahead.
Thank you. Individuals do have a reasonable expectation of privacy in their non-anonymous location history data. this court has said that. Mr. Andrews' location data was real time. His phone was literally turned into nothing more than a GPS location device in the possession of the state. That requires a warrant. We're not saying that cell site simulators cannot be used. Everyone has a cell phone now. It's become an appendage. AI cannot recognize us without a cell phone in our hands. Not that I put much stock in AI, it hallucinates case law. But it my friend just basically admitted that there is a Monell element here, in that Judge Williams and everyone got together and came up with a procedure to not seek a warrant for this technology, but to go around it. Now, do I know if that was because of the NDA? The NDA existed. They were well aware of the NDA. What other plausible reason would they have for not simply going, well, let's just get a warrant? We know what we're doing here. We know we're sending up an electronic impulse. We know that certainly the phone sends out an electronic impulse. It's a back and forth. But the phone picks up on the strongest signal. The cell site simulator becomes the strongest signal. The phone doesn't have a choice. The only choice is turn it off. So we would submit, Your Honor, that this case should be remanded for the fact-finding that was supposed to be done, and not a summary judgment without any kind of identification of what the actual facts are, because the facts seem to have been misunderstood.
You now just said the district court, admittedly, I gave your friend on the other side some grief about that, but I also checked that when they moved for summary judgment, I did not see a response from your client going, no, 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 the Fourth Circuit said make factual findings, you can't do summary judgment. I don't see anything in the district court record where your client objected to the district court proceeding the way it did. Am I right about that?
On paper, we did not. That is correct, Your Honor. In phone conferences, we complained about all of the motions. But we did, because we don't
But
really.
You did not say you're violating the Fourth Circuit's mandate by not making factual findings. You did not say that before to Judge Galvin.
We did not say that, Your Honor. We did not say that. Correct. That is correct. But what we would ask this court to do is remand this for a proper understanding of what the factual predicates are, and what we will discuss in our next session, further discovery.
Thank you, counsel. Any other questions before we take a recess and go into a sealed discussion? Hearing none, Madam Clerk, if you would do whatever we need to do to accomplish that.
Yes, Your Honor. This court will take a brief recess. If everybody could stay on.